Okay, Shannon, put us back on the record.
Go ahead.
Okay, counsel, have you reached some resolution this morning?
We have, Judge, and I will do my best to recite it on the record, and then I'll ask Mr. Benning or Mr. Whiting to confirm it. I'm looking at a different piece of paper. Essentially, what we've agreed per the judgment divorce, Mr. Trepka was to have one of the minor child exemptions, and unfortunately, the defendant took them both. There are only 2 minor children, so the parties are going to both file amended tax returns. That the defendant is going to be responsible for the cost of the filing for both amended tax returns. They're going to use Daughtery Businesses Services located at 3717 St. Luke Drive, Jackson, Michigan. Phone number is 517-529-4611. Both of them will sign a release so that the Daughtery Services can talk to counsel to confirm that both parties got into that service within 14 days of today's date to file their amended returns. My client, the plaintiff, will be taking the minor child, Caitlin, as a minor child dependent exemption and whatever benefits or credits he can get for that child. That the defendant will be taking the minor child, Caden, for the tax dependent and any of the other benefits that she receives for him as a minor child. And the parties, we were going to set a review in 40 days, but I think we're going to go out to August 19th, Judge. And then basically have it renoticed for that day before you to confirm that this has all been done. We anticipate what's going to happen is that, again, I could be wrong, but if the IRS has already overpaid the defendant, they may have to have her settle up before they can issue checks to the plaintiff based on the error in the return that was filed initially. And that's my understanding. The party's going to cooperate and get that done.
Mr. Whiting, can you confirm?
Yes, Your Honor. That is the agreement that we have come to fruition. As I was talking with Mr. Carroll, I'm not 100% sure that that's how that works with IRS with refunds. However, if that does become a fact at issue in this case, Ms. Trepka indicated to me that she would be able to settle up with any monies that were owed back to the IRS within the next 30 to 60 days. So I don't think it's going to be an issue. Ms. Trepka, have you heard the agreement as outlined on the record? Yeah. Are you in agreement with that record that was made? Yeah. And you're willing to be bound by that agreement that you have reached here? Yeah. Your Honor, I'm satisfied.
All right. We could not hear her, but I could see that she was answering affirmatively to all your questions. So I'll simply reflect that for the record.
Thank you, Your Honor.
Mr. Carroll, did you need to question Mr. Trepka?
I could. Andy, do you have an opportunity to hear everything I stated on the record and the additions by Mr. Whiting?
I'm sorry, I couldn't hear you.
Well, that could be a problem. Did you hear what I said as to the agreement on the record earlier?
Yes.
And you're in agreement with that?
Yes.
You got any questions about that at all?
Nope.
And you understand within 14 days of today, you're going to be back at that tax professional doing an amended return?
Yes.
All right. I have no further questions, Judge. Thank you.
So, Mr. Carroll, I believe this may be the very first time I've ever had somebody complain that they couldn't hear you.
Well, in this profession, that's actually a good thing.
I just had a question. Has this tax filing impacted any of the stimulus payments that are intended for dependent children? Has that
Correct.
been covered?
Yeah,
so your settlement would include, if there's been a stimulus payment paid to the wrong parent, that's going to need to be adjusted as well?
Correct.
Your Honor, I would defer that
Yes,
to the
Judge.
tax expert, but my understanding of the stimulus funds is that it goes off of the last tax return that was on file at that time. From Mr. Trepka's exhibits, he did not attempt to file his tax returns until March 29th of this year, all three stimulus funds had been issued before that date and time, the third one having been issued in the first half of March.
Well, Ben, and no offense, taxes weren't due until May 17th. My son filed his own taxes, didn't get his own stimulus money until I think late May. So that's not true. You know, and even for minor children, because I've taken him as an exemption every year before, but I wouldn't have qualified for the stimulus funds for him if I'd have taken him. So I don't think that's correct.
Is on that one, but I'm looking, last night, I'm looking at the IRS website, and they declared that they would issue the stimulus funds based on the most recent tax return on file. And that would have been tax season 2019 for these parties. So the IRS issued accordingly to what was on file.
Well,
But the purpose of the stimulus payment is to support the parent who has the child. So the stimulus payment that was issued ought to match up with their decision as to who's going to claim in a given year. I guess I'm glad I asked the question, because otherwise you would have been back in here perhaps fighting over something else. So does that impact at all the stipulation that you placed on the record?
well, Judge, I said all other tax benefits as a result of having that dependent, which I believed included the stimulus funds. So, for example, Caitlin's stimulus funds and tax credit goes to dad, the plaintiff. Caden's stimulus and tax benefits go to mom, the defendant.
And that was the same way they would have filed in 2019 anyway, isn't it?
Well, I think they just would have been the opposite. He would have taken Caden, and she would have taken Caitlin, and maybe the oldest child, if that child was not filing. They were rotating 2 1 year, 1 year, as long as there was 3 available. Once there was just 2 available, they each take 1.
And as indicated in Mr. Carroll's motion, the oldest one did claim his own tax credit on the stimulus. So we'd still be into a 1-to-1 situation. So it's a moot issue at this point.
All right, very good.
Thank you,
All right,
Judge.
thank you very much.
will
I'll
prepare
watch
this
for
order.
that order. Yeah, and if you do need to be back on the record in August, you'll need to notice that up. We're not putting anything on today.
No, I'll do a renotice just so it's out there and filed ahead of time and provided to everybody.
Okay, very good. Thank you. I'm glad you're able to reach a resolution. Have a nice day, everyone.
Thank you.